they have dealt with so far. And they were going to now continue the process to deal with the creditors.
Okay.
Yeah.
So Samson, I'm actually quite amazed that Mr. Banson,
all stakeholders,
Mr. Banson will suggest that he has ethical boundaries that I don't have, purely by virtue of the fact that he's called to the bar in Ghana. And I guess because myself, as a lowly policy analyst and activist, cannot have ethical boundaries.
That's not what I said. Mr. Simon, that's not what I said.
But you see,
Bright and Bobby, hold on.
I will not.
Bright and Bobby, hold on. So when you were talking and I was talking about the signing, signing process, I picked up these photographs and shared with my production to share with us. And my information is that these pictures, as published, were rather those that were published in 2023.
Yes.
And they were the pictures before Azumah agreement, before the Azumah agreement.
It's got nothing to do with
this is not the transfer that happened.
As you can see, it's a caterpillar.
Thank you very much.
And it has nothing to do with Azumah.
Right,
Okay.
so thank you.
So I am actually amazed that this ethical boundaries issue again, but we're not going to dwell on that, are we? Let's be clear. Even after E&P concludes the ongoing negotiations with Ibarra and signs an agreement, and hopefully they stick to the agreement this time around and everything else. The fact of the matter is that E&P has to raise substantial amounts of money to develop this mine. And as far as the information we have up to date is concerned, it's only public banks that appears to be interested in financing E&P. The ECOWAS Bank and Consolidated Bank of Ghana are the only ones that our due diligence appears to suggest are currently at the level of commitment in this respect. To the extent that those are public banks, we will continue to have an interest in this affair. That's something I'm putting on the record. So that's number one. Number two, it is true that I'm not called to the bar, I'm not a lawyer and the rest of it. But I think Ghanaian professionals sometimes heavily underestimate the interdisciplinarity of most of the things they do. Everything we've discussed here, law is 20%.
Maybe less.
There's a whole range of political economy issues. There's a whole range of commercial transaction issues. I'm a trained MBA. There are a whole range of other matters in respect of public interest, etc., etc. So for someone to suggest that if you're not a lawyer, I can't debate you and this, whatever, I don't think it's correct. Don't worry, Mr. Banson, you'll get your chance. So I think I want to make the
and let's do this briefly because we need to move on to some other issues.
This tendency to think that anything that when there's a legal agreement involved or something, it's only lawyers that can discuss. It's very often the case in this country in public discourse. It's completely wrong. There's so many facets. That's number two. Number three, when I said to Mr. Banson on Twitter and elsewhere that the $500,000 transfer was problematic, I was on very sure grounds. Why is that? First and foremost, Mr. Banson was not in the context in which these transactions occurred, simply acting as a client, a lawyer for a client. He was a member of the finance committee of the company. And in that regard, he has had to pay himself and other members of the finance committee, etc., as if he was an employee. He has had to act as if he was an employee. In that regard, he was not simply a lawyer for some adversarial party, which is why on 22nd August 2025, the adversaries in this situation now, given the fact that they consider the relationship dissolved, sued in that tribunal in an attempt to remove him from the proceedings on the basis of conflict of interest. That was not something I invented. This is something where in adversarial relations, the other party has seen cause to attack upon. I'm particularly convinced that maybe one of the reasons they withdrew quickly from arbitration and then move on to use these Takashi tactics to take over the company was because they were beginning to see that certain interim relief.
Is it fair to be talking about Takashi
I'll come to that in a minute.
tactics?
I'll come to that
because
in a minute.
Once they get to the table, it is always a matter of compromise.
I'll come to that in a minute. I'll come to that. Because some of the things he's saying, if I respond, then I'll be disclosing privileged information.
I will come to Takashi in a minute.
Can say
let him wind up quickly and then I'll finish with you.
Because he raised a lot of issues which are important. So my view of the matter is that in these circumstances where he was in those circumstances, his loyalty was to the company. If the project board had not authorized certain transactions and the likes of it, he cannot go around that and transfer $500,000 into the account of his law firm. When he's in those circumstances, his duty of loyalty is to the company.
So he mentioned something, Bright, which is standard. In fact, we are all required as lawyers and law firms to have a client's accounts.
Good. That client account has nothing to do with this situation because in those circumstances, he was not operating as a lawyer for the company. That's the problem. He was operating as a lawyer for E&P, and he's still a lawyer for E&P. In the context in which he had access to those bank accounts, he was a member of the finance committee of the company.
I'm not a signatory to that bank account.
Yes, but the money went into your account.
I pay myself.
The money went into your account.
I am not a signatory to that. I have never been a signatory.
So that point is very clear.
The signatory to the bank account are the directors of the company.
He will put money from Azumah.
He had explained that
account.
He had explained that his account was holding the money so that the signatories will resolve and then it will revert. And that's what happened.
On whose authority did he transfer the money?
I didn't transfer the money, Mr. Simons.
On whose authority did the finance committee member transfer the money to you?
The money was not transferred by a finance committee member, Mr. Simons. Wait. You are not. Let me explain. Samson, I will do this only for the purposes of educating your public. The agreement that was signed in 2023, okay, had three main pillars. Please give. I didn't want to, but the way he's talking, let me let him know. He had said an agreement for E&P to acquire all the issued shares in the company and debt. It is not only shares.
Yeah.
Shares and debt.
And I can confirm this because I have read the agreement.
For $100 million.
Yeah, okay.
That was the first pillar. Right. The second pillar, so let me go. The first pillar, I will explain it.
Okay.
The first payment was $50 million. The second payment is another $50 million. Up to the first payment was to be made in 2024. The second payment is to be made in 2026. This $100 million is to pay only debt and equity. Now, because the first payment will be made in 2024, the second payment will be made in 2026, the parties agreed that we cannot leave the tenement lying down until the payment is made. What do? In the meantime, we have to look for money to develop the mine. So between 2024 and 2026, the mine was expected to be developed. Okay. Now the second pillar was that E&P will be solely responsible.
Relevant.
Sorry?
I'm not sure why this one.
I'm coming to explain to you the workings of the finance committee.
Operating as a lawyer for the company.
Mr. Simons,
that money to a client account is irrelevant.
Let me explain.
Hold on.
I'm explaining.
Quickly concentrate here and finish because
I'm explaining the finance
need to end this discussion.
The finance committee.
Yeah, go ahead.
But I have
I'm coming.
You said I'm a member of the finance committee and I was paying myself.
Go ahead.
E&P, the second time, was responsible for raising the funding to develop the project. To develop, not to buy the shares. To develop the project. The cost of the funding, as stated in the agreement, was between $150 million and $160 million. Now, in raising the funding, the agreement stated that even though E&P will go and look for the funding, the Australians would guarantee the funding. So the agreement says that the funding will be raised by E&P on the books of the Australians. That's what is in the agreement.
On the books doesn't mean guarantee, but that's another conversation.
That is what the agreement stated. Now, E&P will raise the funding, but the funding is to be raised in the name of Azumah, because Azumah is the benefit for the 2-year period. Now, the parties agreed in the agreement that there will be what is called a finance committee that will be responsible for raising the funds, which is the sole responsibility of E&P.
Right.
So E&P, per the agreement, was to constitute the finance committee. Because this
is the fundraising we understand.
Yeah, this is the fundraising.
The minerals income investment wanted to bring in some money and you rejected.
Exactly.
That you didn't want government
any
to be
political.
involved. Okay, go ahead.
Now, this finance committee was per the agreement to be constituted by E&P.
But for the company.
That is what I'm
you
saying.
finish.
That it will be raised in
We
the
need to
name
do this
of the
quick. We
company,
need to do this quick,
but
yeah.
it is E&P's responsibility.
Right.
All I'm saying is that the
Can I
finance
finish?
committee.
No, you make a
Right,
statement.
right, just a second. Right, just a second. I'll come to you. Right.
The agreement stated that E&P will constitute the finance committee.
Okay.
After the main agreement was signed in 2023, the first meeting of the board was to confirm the membership of the finance committee, which has, of course, it is E&P that is constituted. So E&P would have its people there. Now they needed a lawyer, of course, because you are going to do finance reason. So I was put there on the finance committee. The board of Azumah, in one of their first meetings, ratified all the members of the finance committee and then ratified their allowances to be paid to them.
Meaning they approved.
They approved.
Ratified.
Yes, sorry, they approved.
Okay.
Now, E&P was supposed to fund the monthly operations of the mine, as it were. I'm using the word.
Which you say was funding monthly by how much?
By averagely $500,000 a month.
Okay, go ahead.
From that time.
Yeah.
Now, the monies that E&P would be paying into to fund, for the purposes of knowing that this money was paid by E&P, and it is for this purpose, again, the board of Azumah approved, I was going to say, passed the resolution that a bank account will be opened at EcoBank, where all the payments from E&P would be put into. That we know that every month, whether you've paid your money, you've not paid, so we will not mix it with the other funds belonging to the business. Now, the board of Azumah approved the mandate to this EcoBank account and said this EcoBank account, we are going to have two signatories. One will be A, because of privilege, I will not want to mention their name. One will be Mr. B. Now, Mr. A and Mr. B were members of the board of Azumah. They are the sole signatories of that account.
They were E&P representatives. That's Mr. Nana Jonebemo and Noelado. Of course, I know. I've read everything.
I have never been a signatory to that.
So I don't know why we went all this.
Because you said I was paying myself. You said I was paying myself. So I was trying to let you know that at no point in time was it that the payment from this account to the finance committee was without approval of the whole Azumah board.
Okay.
At no point in time did I, Bobby Banson.
So now I understand where Bright is coming, because he is impeaching the said Azumah representation on that committee.
All. So let me continue.
Or the Azumah board.
It was a board approval.
Yeah, I get it, but he's impeaching them. You know, it's okay. It's okay. Thank you. The point is made.
The information we have seen is that the E&P representatives on the board who were signatories to that account because it was a E&P requirement, but still in the name of the company. So they are still acting in loyalty to the company. Nana Jumebono, Bene, and Noelado, they were the ones who were signatories to the account. So effectively, they transferred the money. But they transferred the money to Robert Smith Law Group, which has no relation whatsoever in this context in relation to a client.
Was the money brought back? Do you know? Did they tell you whether the money was brought back?
Come back
You have said that
but my
it
point
was
is
returned without even a single.
I can share the
opinion.
Right.
My point is that at that moment there was no attorney-client mechanism arrangement in this place. It was simply a fact that in their minds, your loyalty to should have been to the company. So that's all. So that 500,000.
Which company? Well, the thing is that you deny.
Right.
So you deny that claim.
If E&P appointed me to the finance committee
whilst you were a lawyer
for E&P,
right. Okay.
How do you tell me
and
that
you
my
say
lawyer
by the agreement it was E&P that was to set up that committee?
And then pay the committee members.
The account we are talking about was not an E&P account. The account was an Azumah Ghana account.
Because E&P had to account the monies they have paid towards tax purposes. It could not have been direct from E&P to everybody.
Okay, thank you.
You've made your point. Let me just make my point.
Right.
And then
these are factual matters.
Let the US judge.
All right.
So as far as I'm concerned, you were brought on the Azumah Ghana system
right.
as somebody whose duty of loyalty was to that entity. Any movement of funds that was not authorized by the majority shareholders and which they have used as a basis to claim that you had a conflict of interest, it's a public interest. And that's what I have reported. If you disagree or whatever it is, that's your opinion. But you cannot make the argument that what I said was somehow concocted when they themselves have found very
So what it is that you rebutted that. You rebutted that.
There's an important point he's refusing to admit.
Oh, Jesus.
Was the $500,000 brought back after the signatories matter was resolved? Ask him whether he can confirm whether they told you that.
Do you know that as a matter of fact?
No. what I'm trying to explain is,
Can we just clear that?
Do you know that or you don't know?
It
It was sent on 18th November 2024.
there are a lot of issues regarding this EcoBank account.
Okay.
And funds spent in that account that have not been accounted for. Basically, money that was supposed to fund Azumah Resources. The current accusation is that money was funding E&P. So let's not go there. Let's leave that there.
All right. So
my key issue is very simple.
Quickly, yeah.
The ultimate beneficial owner of a company is the person to whom the economic benefits accrue.
Correct.
And on top of that, the person who has control of the company.
Yes.
My argument
These
is
are
that
the people they have dealt with.
No, they have not dealt with them. The person they have dealt with is Hetanyinaku. Now, Hetanyinaku, who was listed as the beneficial owner, who has transferred the shares to them, is not the ultimate beneficial owner. He does not own the shares, because when you look at the actual ownership of the shares, the two companies that he's dealing with now, Azumah Australia and IGIC or IGIC, those companies who own the shares are the true ultimate beneficial owners. The only reason why Hetanyinaku became listed as the beneficial owner
in 2014
because of administrative oversight. Because if you look at it now, I have the evidence now. Can I show something quickly? The current transfer to E&P, it still shows Hetanyinaku as the beneficial owner. So it tells you that unless he now asserts that Hetanyinaku owns the company and not E&P, that is a simple administrative oversight.
Are you saying that you have evidence that in 2014, when Hetanyinaku was listed, he was subsequently sort of delisted?
Hetanyinaku was just secretary. He was not a director of the company.
As beneficial
No, you have
owner.
said that he was listed as beneficial owner.
I'm trying to explain that the beneficial ownership thing, because he was the one responsible for managing it, it was up to Hetanyinaku to ensure that the right beneficial owner was listed.
All right.
Now, what has happened now is that they've taken the company from Hetanyinaku.
Okay.
Not from Ibaira.
Right.
Not from the people that they are currently negotiating.
Right.
But if they are taking it from the right people, they wouldn't be still negotiating with them, would they?
He says the continuing negotiation is not contrary to what the announcement they have
because
made.
he's suggesting that those people are only creditors. They are not
I have
only
not
creditors.
said that.
Those people,
See, that is
Okay.
why I said I don't want to say
are
things for
also
you
the
to go and say.
beneficial
I understand your
You
difficulty.
understand my difficulty?
Understand your
I have not said that.
Yes, but hold on.
I said that. I said
That
that.
if we own
I
the
have not
viewers
said
in
that.
education,
That's right. Yeah.
the people that own the mine are Ibaira.
All right.
Everywhere you go, you end up with Ibaira.
Right.
Ibaira is not the one that has transferred the shares to E&P.
Okay.
There's absolutely no doubt.
Agreed.
Yeah.
So-
the people who have transferred the shares to E&P is Hetanyinaku,
Okay.
who was secretary to the company and does not own any shares and has never been an economic controller or a legal controller of the company. That is why I made the tweet I did, and which is why I sparked the controversy that I did. It was a valid controversy.
Okay. Now, and I need to end on a clean sheet. Does what Azumah is saying still hold? That they are going to the International Court of Arbitration and this must cost Ghana in excess of 1 billion? Yes, I'm asking you, Bright.
Well,
What do you know?
what I know for sure is that E&P sent the matter to arbitration demanding specific performance. That the agreement should continue. Yes, I know.
This is 8th of
Yes, I'm trying to explain that in a few minutes.
September.
Give me a few seconds. So E&P took the matter to arbitration for specific performance, meaning that the agreement as it was should continue. E&P has withdrawn that arbitration and has acquired the shares from Hetanyinaku. That's where we are now. The threat to demand interim reliefs and also pursue the counterclaim for $1 billion. And if they think the Ghanaians are involved in the rest of it, then to find the right nexus for a potential bilateral investment treaty claim. All those matters are subject to Mr. Banson here successfully closing a deal with these people as early as possible.
And that's what they are likely to get.
That is what they are
now.
doing. But they should be careful because the $100 million payment or whatever it is to close the matter does not end for 2 reasons. Does not end the matter for 2 reasons.
All right.
They still have to raise money to fund the mine.
Okay.
And if they keep entangling themselves in warfare, Republic activists and the likes of it, they are not going to be able to raise the money to fund that mine, which will damage Ghana's interest.
Thank
because
you.
our interest for that people of Upper West
Thank
to
you.
get jobs,
Thank you.
for taxes to be paid from that asset.
Thank you, Bright.
And that's
Thank
where
you,
our
Bright.
public interest lies.
You are hopeful that the ongoing process, which you are leaving here to continue,
Yes.
will end this tug of war.
I'm very confident.
So that what E&P has sought to do over the period is complete acquisition, pursuant to the agreements, and to take complete control and develop the two projects. Will happen.
Yeah, it will happen. But I
Okay.
want to end on this note.
Right.
Mr. Simons, I'm telling you for a fact, E&P will never struggle to develop this mine. I don't know what your source is. I can tell you as well, maybe
we hope for the
information.
best. We hope for the best.
Thank you.
Can I finish?
All right.
No, something. He makes categorical statements.
You are making the point. You are inviting him in.
No.
I need to go. I need to cut you right now.
He's saying that E&P has approached only public companies and public companies.
Those are the only ones who have shown commitment.
That is not true, Mr. Simon. Whoever told you, and that is what I'm telling you. That most of the things they tell you are hearsay.
Thank you,
they cannot be
gentlemen.
verified. It is not
Bright
true.
Simons, Honorary Counsel, Imani Africa.